Welcome back to the Business Immigration Benchmark. I'm your host, Laura Blaners, and today with me is our partner, Joey Barnett, to help me sift through a lot of the issues and landscape surrounding F-1 visas, SEVIS program, and terminations that we've seen in the last months. So, Joey, welcome on to the Business Immigration Benchmark. Thanks for joining me today.
Thank you for inviting me, Laura. It's awesome to finally be here and always watch your videos on YouTube. So it's great to be on and happy to talk about the work that we're doing. It's somewhat sad work, not really this type of things that we normally do, but we have been active in this field over the past couple of months since the Trump administration has been picking on international students. So yeah, it's definitely been a tough time for them.
Yeah, so let's kinda set the stage and help us break down because a lot's been happening over the last few months. So kinda wanna understand, like, when did we start seeing these challenges or hiccups for F1 students? Like, when did this all start? And then we'll take it to where we are today. Today, we're recording on June 3rd. So
Yep.
when did this all start, Joey?
So this started at the end of March. Students were being notified that their SEVIS records were terminated, and this was something that was done without the university or college or school's knowledge. And generally, it related to either old criminal issues that had been dismissed or charges that had been dropped or prior immigration violations that had been overcome at consular interviews since then but are being re-brought up. Those types of things caused folks to terminate their SEVIS records, and the way that we have always understood it as immigration attorneys is that SEVIS record is what you need to maintain your F-1 status in the United States and to be here lawfully and to be able to change status or extend status or work. And when we challenge these terminations in federal court, there was, I think, over 200 lawsuits filed by individual students. There was also a class action that was done. We did a few lawsuits in Boston and in California. We did a few, but we argued that, hey, you can't do this. You're not following the immigration law and your own regulations, which indicate how you can terminate a SEVIS record of a student. And we also raised due process issues and things like that. And they changed their policies a couple of times, but that's really what started it. So that was sort of late March through April. There were a lot of litigators going to federal court, filing for emergency relief, and obtaining temporary restraining orders against ICE, preventing them from putting students whose SEVIS records were terminated into deportation or kicking them out. So that was the big sort of immediate harm that we needed to prevent. And for the most part, the courts listened to us and the government kind of changed their policy a couple times. They changed their interpretation of what it means to have a SEVIS record. And so that is all currently playing out in court. Since then, and I would say really like over the past just couple of weeks, there has been a huge turmoil because the Department of State recently indicated that they are pausing consular interviews for F, M, and J students. So if you are abroad and haven't been scheduled for a consular appointment to get that visa put in your passport, there could be delays in getting that issued at this point so that you can attend school come August or September. That's something that is being picked on. There's Harvard University specifically has pushed back, and their SEVIS certification was discontinued or terminated, and they also filed a lawsuit. And just last week, they were able to get a temporary restraining order against the government from terminating their certification because a large number of their students, I would say I think it's like 25% is what I've read, which is more than I thought, but 25% of Harvard students are international students. And, if they're SEVIS is terminated, their SEVIS certification is terminated, then these students are no longer here lawfully. They need to transfer or leave the country. So it's just been chaos and it's been very hard to follow. And it is one of those things where you need to kind of stay on top of it because every week it's something new. It's part of the flood the zone strategy that they have, and it seems to be working. And it is very confusing for employers. It's very confusing for foreign nationals who are here either on OPT or looking to start OPT in the coming months after they graduate. And summer is always kind of a funky time for students because of travel and other goals that they want to do. And just the current administration and everything, it's really changing. I think people are looking at remaining in the US a little bit more this summer as opposed to
Sure.
maybe traveling back. So there's different things that students can do, and then there's different things that, employers can do and schools can do, and so that's kinda what we're talking about here.
Yeah, and so what I heard then is sort of in March, we saw the administration take an aggressive approach for trying to challenge or cancel students that are currently here, and that was not done through the universities. So there's also sort of this personal compliance issue that the foreign national students have to sort of manage, but may implicate their ability to maintain their status to continue to attend school or postgraduate maintain their status to work at a employer who's already hired them or has an offer out to them. So that was sort of the first wave, and then now we're seeing waves of, Harvard's SEVIS program being canceled and then the lawsuits back and forth there. So we think that that is in place now, but that litigation will proceed, so we'll track that closely. Then we're seeing, if you're a new student and you haven't already been interviewed, you don't have the visa stamp, you might not have the ability to come in and start your classes. So we're seeing it at 2 fronts. People that are already here, facing, you know, challenges to stay, and the ability for new students to enter the US, right? We sort of have these 2 categories of challenges happening simultaneously in the US.
Correct, and I guess there's even a sort of you can separate out one of those categories between students who are just going to school and then students who are engaged in OPT. And that is optional practical training is what OPT stands for, and it's an employment authorization program available to certain F-1 students, and it allows those students to gain work experience related to their field of study in the United States. And generally, you get 12 months to do that after graduating. And if you have like a STEM degree, science, technology, engineering, or math, you get an additional 24 months of OPT. And so one of the rules with OPT is that there's only a certain amount of time that you can be in the United States and have unemployment. Under the current rules, students are allowed up to 90 days of unemployment or 150 days for those who are on STEM OPT.
That's a great thing to bring up because I think, I work with a lot of employers, a lot of companies who wanna help out F1, OPT, STEM folks sort of matriculate into more, permanent status, but at the OPT or the STEM OPT, there's a lot of individual compliance. So can you tell us a little bit about, like, how F1s are managing this compliance network? Given all these challenges and disruptions and sort of unknowns?
Yeah, there has always been sort of this requirement to keep track of your time of unemployment in the event that something were to happen later on. You can say that you've always maintained your status. The immigration concern is that if you are unemployed for 90 days or more, or for more than 90 days, I should say, then you're no longer maintaining your F status. And for an employer, that means that, potentially that employee could not be onboarded as a new, you know, to start working for the company.
Yeah.
That's the concern. And so the way that students are supposed to do it, and something that has actually happened just in the past couple of weeks, is they are getting emails saying, hey, you need to update your SEVIS record online. And if you don't do it within a certain amount of time, 15 days, something like that, then your record could be terminated and that you have a violation of status. because you have failed to timely report your OPT unemployment. And so that is sort of the new thing that is coming up that individuals must take care of to maintain their F-1 status,
Yeah.
right? That's not something that an employer does.
Right.
That's something that a student does when they're working on OPT or STEM OPT.
No, that's such a good point because a lot of the employers that I work with, the companies don't have any involvement in the OPT or even the STEM OPT process, that they require the F1 employee at that point to sort of manage their individual compliance. But I will tell you that I think most of those students are just managing getting the EAD card, which is the proof of work authorization in the OPT status, and that they have limited knowledge about what the sort of SEVIS reporting compliance is. And especially in light of I've seen waves of layoffs at my companies, and, I say it's your individual obligation to report that back to your school to, comply with SEVIS, and they're like, "What?" And so I think this is a big red flag for employers if you're supporting or sponsoring or hiring OPT or STEM OPT F1s, you gotta be aware of where their unemployment, did they properly report it, and asking those questions, which you wouldn't really know until there's maybe a status cancellation or something that now is being very closely scrutinized, it sounds like.
Right, and from the student point of view, I would say you gotta maintain contact with your DSO and the International Student Office. Even during OPT, it's very important, and I would say, take corrective action as soon as possible, do not delay. This administration has been relentless in using ICE to put people in deportation proceedings, individuals that I guess historically haven't been put into removal proceedings. The painting is on the wall, so to speak, and we see that they are picking on folks. And, this goes beyond people who are, in my mind, people who are politically active, they're
Sure.
beyond the First Amendment right type things that are being, litigated, to be honest, about, having your First Amendment rights to give your point of view even if you're a student. And, historically, I think students have had those rights. Now there's a pushback against that. We're gonna need to see where courts sort of draw the line on that. It's definitely an interesting time. Everything that I tell about the Trump administration and what they did in their last administration is it's not like, well, yeah, they're creating new laws, but a lot of times they're really just enforcing the existing laws and making sure that it's sort of strict compliance
Right.
and zero tolerance if you aren't complying with them, right? Like they can make mistakes, but you can't. And you make mistakes, there's huge consequences. They make mistakes, okay, well, nothing, sure, that's
We'll
just
get around to fixing it.
we'll get
Yeah, no,
around to
it's
fixing it, exactly. But for students or for foreign nationals, that leeway is not there right now. And so that's why it's so important to, work with your immigration attorney, work with your DSO, work with your employer to maintain your compliance.
I think that's a good thing to highlight because this is a lot of, like, technical violations that I think students were not historically aware of, and, this might have been in the packet your DSO gave you when you, started your orientation or had your first conversation with them to get your I-20, and then was, like, quickly put aside and you never really thought about it again, and so I think that, to your point, like, there is 0 tolerance for any type of noncompliance, and, a very quick turnaround in the reporting. So these days, I think, if we have any F1 students listening or HR, global mobility leaders listening, I think, checking in with immigration attorneys, checking in, running reports for your F1 students to know what population, you're managing or may have some exposure, checking in with them about what they're reporting when they've completed reporting, because employers historically just look at that EAD card, and facially, that's the only document the employer, like, needs to accept, to onboard them properly, but as we're discussing here, the F1 has a much deeper compliance requirement with reporting back for their OPT, whether that's complying with, the unemployment days. And then when they apply for the STEM OPT, should they qualify because they have a qualifying STEM degree to get their additional employment authorization for an additional 2 years, they do have to coordinate with the employer to complete a training plan. And the employer will often do that, to sort of say, this is the role, these are the sort of performance evaluation, hand it off and never think about it again. The employer does have an obligation to report into the DSO if there's a termination of that student. I don't know how many employers are actively doing it, but again, could cause some compliance issues if the F1 is also not reporting it and then keeping track of their unemployment days, as Joy's mentioning. So there's a lot to unpack here. And it sounds like what we're seeing is aggressive pursuit of these technical noncompliance. Does that sound right, Joey?
Correct, and I would say to some extent, I mean, we haven't really even touched on what Marco Rubio mentioned last week
Right.
about China. There's political or geopolitical elements to this as well. The Department of State Secretary Marco Rubio was saying they're going to, aggressively revoke visas of Chinese students, including students who may be on OPT or STEM OPT, in particular those who have ties to the Chinese Communist Party or whose parents have ties to the Chinese Communist Party, or students who study in STEM degrees or other critical fields where they believe Chinese nationals are taking advantage of the United States and the knowledge that they gain here in the United States, and bringing it back to China, and that's a whole other aspect of this that
Yeah,
that's it's based on national origin. There's a whole host of legal issues there as well,
sure.
but there's also a lot of discretion and authority for the federal government to impose limitations in these visa programs, and they are, pursuing that and sort of pushing the edges of where it's been.
That's a great point, and that, we obviously can't give legal advice here, but what I hear when I hear, critical fields or connection with Communist Party, I hear such broad terms there, like, what is a critical field, right? It's up to so much interpretation, that I think it could be very sweeping when they sort of list that as a criteria for visa revocation. Any kind of involvement with the Chinese Communist Party, again, is very sweeping, and what I would expect to come out of this is a lot of people getting visas revoked because they're put into this big qualifying criteria that they're putting out there. My question to you is when we hear Marco Rubio say, visas are gonna be revoked, what does that mean for someone in the US? So let's give an example, hypothetical, someone's an F-1 OPT, has a valid visa stamp in their passport. When Marco says
Little Marco.
when Marco Rubio says that the visa is gonna be revoked, what does that mean for that person? Just sort of broadly speaking. Does that mean they're gonna be put in deportation proceedings?
It can, yes, eventually get there, which is not great, but if your visa has been revoked, then potentially, so a visa is just a document that you use to make an application of admission to the United States.
Right.
It does not by itself give somebody status. When someone comes in and then they get their stamp by CBP, that's when the status begins. So if someone's visa is revoked, the way that I've always understood it was, well, if you leave, you can't use it again.
Right.
You gotta go back to the consulate, or you have to figure out what was wrong, come up with some inadmissibility waiver or whatever the case may be, and try to apply for a new visa. But for those who are in the United States, that doesn't impact your status here. There's something called a prudential revocation, which is a little bit different, but it's a very expansive authority by the Immigration and Nationality Act, and they say if there's good and sufficient cause, and because it's discretionary, there's a lot of wiggle room right there. So it is a huge issue. I think the other kind of concern that we're seeing is because it's discretionary, it can be difficult to challenge revocations in federal court. And so, that is one avenue that, and pretty much the most successful avenue of challenging this stuff is in the courts, and that is seemingly blocked here. and it's definitely troublesome. But I would say, don't leave the United States.
Right.
Is kind of my main point here. Back in March, when students started getting these notices, some of them were like, "Oh, I gotta go."
Right.
They didn't finish their semester, and they just left. And it's much more difficult to challenge these if you're outside of the United States than if you're inside of the United States. And so if this happens and you're notified that there's a revocation of your visa, you need to call an immigration attorney and talk to them because there's probably some emergency relief that you may want to pursue in order to prevent any deportation or removal from happening and ideally keeping you able to work.
Yeah. Well, and so can you tell me sort of this very it seems like a very basic question. How would this F1 student how would they be notified of their visa being revoked? Like, practically, how are they notified?
From what I understand, they're getting emails.
Okay. So, yeah, if you receive this email, your first step is to call an immigration attorney before you sort of make any travel plans. So that's, the guidance here. And that, from the employer side, that's all to say that, if you're employing F1s who are having visa revoked, practically you're not going to be notified as the employer. It's going to be the individual notified via email. And then they have to disclose it to you if they're in some sort of, jeopardy. So it's a lot of self-reporting and not much employer involvement in the process.
It's definitely, I think, can be challenging on an employer because it is sort of in the control of the student, the foreign national, and potentially they may have had up to 90 days of unemployment before they are accepted as an employee, right? And if that's the case and they've exceeded their permissible period of unemployment, then they're technically not maintaining their F1.
Totally.
And, you know, again, it's a crazy time, and we're trying to figure out the right ways to be doing it, and I think it's just like I said before, you really have to stay on it on a weekly basis, or at least have an immigration attorney who's staying on it on a weekly basis.
Yeah, I'm briefing you. Yeah, I mean, I know that, in the last 2 weeks with all the movements of, Harvard's program being canceled, Marco Rubio's statement about, potential Chinese student visas being revoked, constantly updating my clients who hire from Harvard grads. We can pull reports to know who has graduated from Harvard that might have been impacted, so that was a nice fire drill 2 weeks ago, and then this week's fire drill was about the Chinese F1s and, pulling those lists with the sort of immediate consideration of, like, do not be sending these folks on business travel, and then also here's the message to send about if any sort of personal travel, because with the start of a lot of intern programs, sometimes the program doesn't start until mid-June, and so some of these students might have gone home for a couple of weeks, before their internship started, so there were a few F1 Chinese visa holders who returned abroad, for vacation and were very concerned about bringing them back in. Will they be able to, reenter the US? Because again, if like Joey said, if the visa's revoked, they're not gonna be able to make admission because that's the document that allows them to travel into the US. So that was a sort of an immediate concern and again, another fire drill. So, from employers at this point, it's really just having solid reporting to sort of understand what population is, at risk with all these movements and then, following up with them because they may not be actively receiving communications about their status or they might be confused. Now, I don't suggest that the employer serve as counsel, but it's really like, as the employer, you want to make sure that they're maintaining valid status for your own employer compliance piece. So there's just like so many layers to this that keeping track of it can be quite tough if you're not working with counsel that can help you navigate it.
Yeah, you need those systems in place. You need those systems in place for sure. I don't know how else you would be able to do that. Without that,
Right.
you're kinda you're sort of lost at sea a little bit with this because it is a little bit outside the scope of employer sponsorship, normal employer sponsorship.
Yeah, I wanna shift Joey into, like, okay, because this F1 and managing F1 is really, like, on the individual, and so I kinda wanna shift into, what can F1s do to sort of take their immigration journey in the US or their status in the US, like, into their own hands? Like, obviously finding a good immigration attorney to work with, but, like, what else do we think they can do to sort of secure status when this feels shaky, which it never has in the past, quite frankly, in my practice?
right? Well, that's why I've kind of been brought in on this is because I generally do green card immigration, investment-based immigration, EB-5 investments, and more students are turning to that because they are having trouble getting employers to sponsor them, or they are looking at just their future of what they want to do and see sort of where US immigration is, and they're looking at long-term sort of planning. And so they're going EB-5 straight from F-1 status. And what's really great about that, at least currently, is that a student can file for EB-5 and file an adjustment of status at the same time. And that student can have an EAD based on that pending adjustment in potentially as quick as 4 to 6 months. And that is an unrestricted work authorization that the individual has, and the individual can remain in the United States beyond any date that is listed in their I-20, as long as they entered lawfully and filed that adjustment within, while they were maintaining F-1 status. And
Right.
so a lot of times students want to find OPT and then they want to find an H-1B sponsor and then they work for a few years, show they're a good employee. Then they get a perm sponsorship and they get the EB-2 and EB-3. That's kind of the normal course of US immigration and how a lot of foreign nationals in the United States get their green cards. EB-5 is sort of an alternative route that doesn't require employer sponsorship. It requires an investment of lawfully obtained capital, and that money can be gifted money, it can be money that is lent. And so we do have a number of clients who are here on F-1 who are students whose parents have lent them money or gifted them money, or maybe there's money in a family trust, and they are able to remain in the United States indefinitely during the time in which their EB-5 case is pending, and in the interim, they get that unrestricted work authorization. So that is a huge benefit right now that we are seeing. Of course, it is pricey. The minimum investment is $800,000, so it doesn't. It's not. Not everyone is eligible for it, obviously. Um, but for those who are eligible, or whose parents are can help sponsor that type of thing, we are seeing a big demand on that right now.
Yeah, that makes sense in terms of, taking ownership of your immigration journey. And, when you graduate, when an F1 graduates, like Joey said, the sort of immigration journey through an employment based sponsorship can be quite lengthy. And, I have Indian born, Chinese born clients that are sponsored by companies I work with that, their immigration journey is still ongoing 12 years after they've graduated. So, this is a way to sort of fast track it, so to speak, which again is quite pricey, but is an avenue that I think we definitely wanna make sure people know about to explore, especially given sort of the uncertainties of the sort of longevity of the F1, because I think the other thing that we're seeing, in reporting here is, what is the USCIS or US Citizen Immigration Services, policies towards F1s. We saw a potential new director talk about wanting to sort of remove the STEM extension for OPT. And so it sort of really cuts off opportunity for foreign graduates to work in the US and then ultimately for employers to hire and then sponsor them. So it's really like a warning of if that goes away, what happens to opportunities for these F1 students, and honestly, could be a big signal that there's gonna be fewer and fewer F1 students entering the US, which may be what this policy proposal is meant to do.
I think you're 100% right. That is what sort of the point is. And for Chinese and Indian nationals who are stuck in EB-5 visa backlogs, maintaining their H because they have that approved I-140. A number of my clients, actually a large majority of my clients right now doing EB-5 are in the United States in that position. It's just it's a question of supply versus demand. And there are a lot of people who want EB2 and EB3 visas. And with the per country caps and everything like that, there's a limited supply. The same can be said for EB5, but there is this opportunity because new visa categories were created that they remain current in the visa bulletin, and people are taking advantage of that. So that's the big sort of opportunity that exists is if you look at the visa bulletin, you'll see that it's pretty much there's backlogs everywhere except for EB5. And that is what allows an individual to do an adjustment of status and remain here indefinitely during the filing of the EB5 petition.
Excellent point. Yeah, and you do a lot of debriefing with Charlie Oppenheim about the EB5 visa bulletin and why this window exists. So, just a little shout out that if you're like, what's going on? Or I have no idea about this, we have a ton of content. Joey's got a ton of content. We'll put a link here to direct you to check out those resources because it is really valuable resource that you put out monthly with Charlie and dive into what's going on there and how to take advantage and file in those categories should you be eligible.
Exactly. Yeah. Charlie's pretty amazing. He puts on his wizard hat, and we get to talk about the future with his crystal ball. So it is pretty fun. For serious, um, EB5, I would say if this is something that you can do, it's something that you want to be looking at in 2025. This isn't something that you will be able to do necessarily in 2026, or at least in the second half of 2026, because it will not be current forever. As they approve more cases, that demand increases, and once that demand exceeds the supply, well, then there's a final action date, and that prevents someone from doing an adjustment of status. So if you're gonna do EB5, now is the time to talk to your parents about it now, and I would say try to get your case filed within the next 3 to 4 months so that you get your spot in line.
That makes a ton of sense, Joey. Thanks for that update and something that, is not my area of expertise. So glad to have you on to sort of tell us more about that. Any kind of final thoughts about, the F1 trajectory, the landscape that we're in right now overall?
It's a scary time to be a foreign national at school right now. And just to reiterate what we had kind of said, you have to maintain contact with your DSO. Make sure you're keeping track of any times of unemployment if you're on OPT, and really just stay educated. I think that's the best way to proceed here is you just got to stay on top of it because there are changing policies on a weekly basis and it can severely impact your life and change you. So, that's why we're here and hope to hope to continue to shed some light on it.
Yeah, thank you for that. And that, from the employer side, hiring talented F1 students post graduation or for internships, there's not really a role that the employer can step into other than sort of being educated and having reporting systems to sort of understand what populations you have and how to, communicate with your immigration counsel that you're working with about the latest that's happening to sort of support the proper information flow. That's about all that you can do in these types of situations to support your F1 foreign national employees. So again, tough time to be an F1 student, and that from an employer side, there's only so much they could do to support. So Joey, thank you for joining us. We'll put your contact information. I
Thank
know
you
that
for
you're
having
active
me.
on LinkedIn and YouTube. So there's a lot of great content coming out from Joey and the WR team. We'll catch you next week on the Business Immigration Benchmark.